compounds the illegality of the proceedings premised on acts of fraud, forgery, and misrepresentation. Now, honorable senators, in urging the Senate to find that the threshold of 2/3 of all members of the County Assembly in support of the impeachment motion was not achieved, Counsel Elias Mutuma for the governor stated that the County Assembly of Nyamira comprises 35 members and that therefore the requisite 2/3 majority for a valid impeachment resolution was 24 members of the County Assembly. Council further submitted that the official record of the sitting of the County Assembly held on 25th of November 2025 confirmed that only 19 members were physically present in the Assembly chamber. Council stated that despite this, the Assembly recorded 23 votes in favor of the motion and that this was numerically impossible, and that to him, this demonstrated that improper and fraudulent voting had occurred. Now, Counsel for the Governor submitted that the phrase, all the members of the County Assembly in Section 33(2) of the County Governments Act is not ambiguous and refers to the total composition of the County Assembly as established under Article 177 of the Constitution and as gazetted by the Independent Electoral and Boundaries Commission after the 2022 general elections. Now, Council contended that as a membership of the Nyamira County Assembly is 35 members, and as 2/3 of 35 is 23.33, this can only be rounded off to 24 members. Now, Council further submitted that the County Assembly's argument that the 3 vacancies in the Assembly reduce all the members, end quote, from 35 to 32 was legally flawed and absurd. Council therefore urged that for these reasons, the impeachment proceedings before the Senate could not proceed and required to be terminated at the preliminary stage. Now, Council for the County Assembly took a different view on this matter. The thrust of the argument in response to the first preliminary issue was that the Independent Electoral and Boundaries Commission, IEBC, in Gazette number 9956 of 2022, published on 24th August 2022, set out the names of the elected members of the Nyamira County Assembly, and further that this was not the limit or absolute number of members who were required to sit in the Assembly at any given time. Council further noted that when the Constitution and the County Governments Act imposed the requirement of 2/3, this could only refer to 2/3 of the members present at any particular time. According to the Council, an alternative interpretation would mean that no activity could go on should there be a vacancy or a challenge in filling the vacancy, and further, that any business that has been transacted by the County Assembly of Nyamira on the basis of the members of the County Assembly of Nyamira at the time will be null and void. Council further stated that this issue is a question of fact that ought to be determined through the examination of evidence during hearing. On the second limb of the preliminary objection relating to voting by proxy by the 4 members of the County Assembly, Counsel for the Governor stated that this was alien to the County Assembly procedures, illegal and null and void. Council further stated that no authority was granted by any member to vote on their behalf by proxy, and that the 4 members of the County Assembly in whose names proxy votes were recorded had provided sworn statements confirming that they were neither present in the Assembly nor did they issue an authority, written or otherwise, for any members to vote on their behalf. In this regard, Counsel for the Governor referred to the Standing Order 67 of the Nyamira County Assembly Standing Orders, which requires the decision of the Assembly be made by members present and voting. Council argued that the act of proxy voting was expressly prohibited and was a nullity as it contravened Standing Order 67 of the Nyamira County Standing Orders and the principles of representative democracy. It was Council's case that the unauthorized casting of votes in the names of absent members without the authority constituted fraudulent misrepresentation, forgery, and impersonation, further vitiating the entire process. As such, the Governor takes the view that the maximum number of voting MCAs would have been 19 MCAs. The governor concludes that the required statutory threshold of 24 members of the County Assembly to support the motion was not achieved. In response, Counsel for the County Assembly stated that the delegation of voting by proxy was carried out in a right manner, and further that the proxy letters were available as evidence of the said delegation. Now, in support of this submission, Counsel referred to the case of Mukisa Biscuit Manufacturing Company Limited versus West End Distributors 1969 EA at page 696, which set out the threshold for a preliminary objection. In particular, Counsel stated that the issues raised and in question, that is the number of persons who voted, was a contested fact that ought not to be argued at the preliminary stage. He further stated that although the Governor's Council had indicated that there was evidence of affidavits sworn by 4 members of the County Assembly, averring that they did not delegate such authority, the County Assembly would, at the hearing, provide evidence of mobile telephone and email communication to counter these allegations. It was therefore not possible for the Senate to make a determination on the matter at the preliminary stage without hearing evidence on the matter. Now, Counsel further argued that although proxy voting was not expressly provided for in the standing orders, the Speaker of the Nyamira County Assembly had exercised the discretion provided for Standing Order 1 of the Nyamira County Assembly standing orders to allow for the proxy voting. He further stated that although the standing orders were silent in expressly providing for proxy voting, this did not bar the use of proxy voting in the Assembly. Now, Honorable Senators, following the oral submissions on the preliminary objection and the responses, Senator Edwin Sifuna, Senator Enoch Wambua, and Senator Boni Halwale sought various clarifications from Counsel, including on the relationship between provisions on the Constitution, on vacation of office by members of Parliament or county assemblies vis-a-vis the provisions of law as that set out threshold for voting on a matter, at what point the membership of a county assembly is determined after election, or whether this is a moving target, and whether it will not be prudent to give the county assembly the opportunity to adduce evidence on the matters raised in the preliminary objection in the main hearing. Subsequently, the respective counsel gave the responses to the questions and clarifications sought by honorable senators. Arising from the preliminary issues canvassed, the following are the issues that require determination by the Senate. 1, whether the preliminary objection raised qualifies as a preliminary objection, properly so called, and whether, therefore, its determination must precede the further progress of the current impeachment process. And 2, if the answer to the first issue is in the affirmative, then whether the 2/3 threshold required for voting on the impeachment motion of the County Assembly was met. Now, honorable senators, I shall commence with the first question, which is whether the preliminary objection raised qualifies as a preliminary objection properly so called, and whether, therefore, its determination must precede the further progress of the current impeachment process. As you will recall, the Senate has previously been confronted with this question in previous impeachment proceedings. The question of what constitutes a preliminary objection was well set out in the leading case of Mukisa Biscuit Manufacturing Company Limited versus West End Distributors. And this is what, in that matter, the court held. A preliminary objection consists of a point of law which has been pleaded or which arises by clear implication out of the pleadings, and which, if argued as a preliminary point, may dispose of the suit. Examples are on the objection to the jurisdiction of the court, or a plea of the limitation or submission that the party